to Group 7, and this is requests as to persons by whom forensic medical examination carried out. Can I call Amendment 28 in the name of Johann Lamont in a group on its own? Johann Lamont to move and speak to Amendment 28.
Thank you very much, Presiding Officer, and may I move the amendment in my name. We all know this is an important piece of legislation for all victims of sexual violence, and we also recognise that it continues to be a crime perpetrated overwhelmingly by men on women. This legislation seeks to make practical steps, trauma-informed, to allow victims of sexual violence to take back control and have consent, following the horrific experiences where they had been denied both. For context, in relation to my consideration of this amendment, as someone with a long-term interest in this field, I sat through the Stage 1 debate, and I cannot overstate the impact it had on me. I was moved and hugely affected by the quality of the cross-party agreement, the powerful speeches and the substantial nature of the recommendations. Members of the committee spoke about the courage of survivors who had given evidence at a meeting facilitated by Rape Crisis Scotland. And it was evident that those survivors had a huge impact on members, and I have no doubt that their testimony shaped the committee's thinking and its thoughtful recommendations. This amendment seeks to give force to the recommendation agreed unanimously by the committee. It says, we consider the definition of gender could be ambiguous in the bill, which has the potential to cause distress to individuals undergoing forensic medical examination. We recommend the bill be amended to guarantee an individual's right to choose the sex of the examiner. No one spoke out against the recommendation in the debate, and a number spoke explicitly in its favour. No group or organisation spoke against the Stage 1 report or any of its recommendations when it was published in September or when it was debated on the 1st of October. So this amendment simply reflects a recommendation in a Stage 1 report thoughtfully considered. At that point, it did not seem to be problematic, and there was no evidence that the people had concerns. So to be clear, if members do not agree that women survivors of violence and rape should be able to ask for a women's examiner, then say so, and we can have that debate. But be clear, as Rape Crisis Scotland said, that is what women survivors explicitly sought. So if you do agree, we should all do what we can to make that wish real. Those who are now expressing concerns about this amendment make a number of points, and I want to address those, and will of course take the opportunity to address further ones as they are raised. Firstly, the point is made that there are not enough female examiners, so the amendment is meaningless. But that is to argue that the provision is meaningless, not the wording. If the provision is meaningless, the logical position would be to argue for its deletion instead of resisting a change in wording. And what a counsel of despair. Are we simply to give up because we currently do not have enough examiners? The survivors of abuse are not fools. Of course not. This legislation can and should drive change, translating through workforce planning and spending a real difference in provision. And is that not why we as legislators are here? Secondly, we are told there is no reason to change because the words sex and gender are interchangeable. But if they are interchangeable, why resist an amendment which uses a term defined in law? If it does not matter, why fear clarity? But of course, these terms are no longer interchangeable, as I have come to realise. And how do I know? Because in various statements, Fiona Hislop, a government minister, has said we would not conflate sex and gender. Shirley Ann Somerville, a government minister, has said we should not conflate sex and gender. Hamza Yousaf, a government minister, has said we should not conflate sex and gender. And in gender, Rape Crisis Scotland, Zero Tolerance, at various points in recent times, amongst other groups, have sought definitions of gender which are explicitly not interchangeable with the word sex, a word defined in the Equality Act of 2010. In giving people rights, in giving women victims of rape and sexual assault rights, in giving all survivors of sexual violence rights, we need to be precise. Sex is defined in law and gender is not. A right is not a right if it's unenforceable. We owe it to survivors to listen and treat them with respect. So, in summary, survivors showed great courage in shaping this bill. The committee showed great integrity in responding to their evidence and unanimously agreed the recommendation to which this simple amendment responds. There is a direct, traceable and powerful course from the survivors' testimony to our decision on this amendment here and now. And I could put it no clearer than the statement of one member of the committee who said, "I feel a sense of great responsibility, not only to speak to ensure that the bill fully serves its purpose, but also to use this platform to give voice to those who have been silenced for so long." That is our challenge now. If we applaud survivors for their courage, if we are moved by their testimony, it is our responsibility and duty to respond. It is what we are for, and I trust members will agree and vote for my amendment.
Thank you. I call Sandra White to be followed by Donald Cameron. Sandra White.
Thank you very much, Presiding Officer, and may I thank Johann Lamont for putting forward this amendment. This bill is very, very important. Yes, it is emotional. It's really important for the survivors of sexual abuse. I go by the evidence that we were given by the women, very courageous, who gave us that evidence. I also go by the evidence we got at committees from organisations, and unanimously the committee, as Johann Lamont has said, supported this at stage 1. At stage 2, I also raised the issue and was comforted by the words that the Cabinet Secretary gave to me and to the committee, that if a woman asked for a female examiner, they would receive that female examiner. I also, on the evidence that was given to us by the women, the survivors, this was one of their top priorities, to be able to ask for a female examiner, female doctor, female nurse. And we heard very emotional contributions from the women survivors. They were very uncomfortable, they were in trauma, and to be examined by a male doctor traumatised them even further. So I do thank Johann Lamont for bringing this forward. I'm certainly in support of this amendment. It could be placed as perhaps technical, as the Victim and Witnesses Bill, but this debate and this bill is far too important to not support, in my belief, this amendment. Thank you, Presiding Officer.
Thank you, Ms White. And I call Donald Cameron to be followed by Monica Lennon.
Thank you, Presiding Officer. The Scottish Conservatives will be supporting this amendment. As others have said, we believe that the views of the Health and Sport Committee are very important here. The committee unanimously recommended that the bill be amended to guarantee an individual's right to choose the sex of the forensic medical examiner in preference to the word gender. Of course, this does not necessarily mean that female victims will get to see a female forensic medical examiner, because there are issues of staffing, and that is something which the government needs to address going forward and do so urgently. There is plainly a wider ongoing debate and an important debate about rights of gender and rights of sex. But in my view, that is not what we are debating here. The issue here is very specific. And if ever there was a practical example of an instance when the word sex should be preferred over gender, then this is it. The time at which a victim of a sexual assault requires a forensic medical examination is likely to be a moment of deep trauma and needs handling with great sensitivity. And at that point, and in these very specific circumstances, we believe the choice requires to be one of sex and not gender. There is one other issue to reflect on, and it was mentioned by Johann Lamont. It's a legal one. The Equality Act 2010, 10 years old this year, and the place where all protections against unlawful discrimination are located, uses the word sex, and it has a legal definition. Now, again, there is an important debate to be had about that and whether that list of protected characteristics needs updating. But that, too, is not for now. And for these reasons, and for the very powerful and compelling arguments made by Johann Lamont, we will be supporting this amendment.
Thank you very much. And I call Monica Lennon to be followed by Andy Whiteman. Monica Lennon.
Thank you, Presiding Officer. I strongly welcome this bill and pay tribute to Rape Crisis Scotland and other women's campaigners who have campaigned for years to bring this about. In relation to Amendment 28, I firstly want to say that I fully support the principle that survivors of sexual violence should have the right not just to request a female medical examiner in the aftermath of a sexual assault, but for that right to be realised in practice. However, it would be misleading to give anyone the impression that the amendment and the passing of the bill by itself will ensure survivors get timely access to a female forensic examiner. It is a sad fact that the bill by itself will not lead to a material change in circumstances for many survivors. As we've heard, there's simply not enough female examiners in the profession currently to meet that demand. So beyond the bill, increasing the representation of women forensic examiners is where our collective focus must now be. Like many MSPs, I have received correspondence over the last few days asking me to support Amendment 28. Whilst much of the content of those emails is genuine and sincere, there are some that are unfortunately blatantly hostile towards trans women and the trans community. This is troubling, as is some of the narrative abuse and trolling that I have seen on social media. Clearly, there are some people who want to exclude trans women from working with women and girls who have disclosed rape or sexual assault. And there are some people who believe that Amendment 28, which replaces the word gender with sex, will help to achieve that, because they are of the view that this amendment will prevent trans women from carrying out such examinations. And this is not correct, because under the law, a trans woman with a gender recognition certificate is legally of female sex. Johann Lamont is correct to say that clarity is important. And I believe it is important that any misinterpretation is cleared up. And I hope that all colleagues will take the opportunity to assist with that and condemn any unacceptable abuse that they see towards Rape Crisis Scotland and others. Because Rape Crisis Scotland, in their recent statements, have simply correctly stated that this amendment by itself makes no practical difference. And finally, Presiding Officer, I want to put on record again my thanks for the work of all of those staff and volunteers at Rape Crisis Scotland. The online abuse that I have seen targeted towards them in recent days is unacceptable. There must be zero tolerance for it, and we should all be calling it out. It is thanks to the work of Rape Crisis Scotland over many years that we have this bill, and that it will help many survivors of sexual violence. I commend the Scottish Government for introducing the bill, and I look forward to working with ministers on a strategy to address the underrepresentation of female forensic examiners and towards the eradication of gender-based violence towards all women and girls. I look forward to the bill passing tonight and for us all to collectively focus on supporting survivors through our words and our deeds. Thank you.
Thank you, Ms Lennon. I call Andy Whiteman to be followed by Emma Harper.
Thank you very much, Presiding Officer. This debate is about victims of very, very serious crime. Some of the most heinous crimes that can be committed against a person. And as Rape Crisis Scotland state, the feedback we have from survivors is that the most important issue is access to a female doctor. The lack of access to a female doctor is what causes the most trauma. I've thought long and hard about this, and I'm speaking in my own capacity. Victims of crime have told me directly how important it is that access is available to a female examiner, and I thank them sincerely for the experiences they have shared with me. That importance, Presiding Officer, is beyond any doubt. Now, I came to the view after looking at this proposal early this week in what has been an extremely busy week, that the statutory interpretation of Section 9 of the 2014 Bill was clear. It was clear because the intention of the Stage 2 amendment, lodged by the Cabinet Secretary for Justice, Kenny McCaskill, at the time, was to do precisely what Scottish Women's Aid and Rape Crisis Scotland wanted at the time, namely, that female victims, survivors, should be able to request a female doctor. It followed debate on what became Section 8 of that Act, the right not to actually just request, but to actually be interviewed by a female interviewer. And that provision was in order to implement an EU Directive 2012/29 of 25th October 2012, which established EU minimum standards on the right, support and protection of victims of crime. And Article 23(2)(d) of that directive states that measures shall be available which include that all interviews, and I quote, with victims of sexual violence, gender-based violence or violence in close relationships, unless conducted by the prosecutor or a judge, being conducted by a person of the same sex as the victim, if the victim so wishes, provided that the course of the criminal proceedings will not be prejudiced. And what became Section 9 of the 2014 Act was agreed as an extension to the then Section 8 provisions. So I'm not convinced that it is necessary to make any amendments to the 2014 Act to secure its principal purpose of ensuring that victims have some say in the sex of their examiner and their interviewer. And the conflation of sex and gender in this context is not, in my view, particularly problematic, as it's very clear from the intention behind the 2014 Act and Principle Section 8 and Section 9 that it was indeed to provide access to a female doctor where a female victim requested that, and to the extent that the courts will always interpret legislation in line with what the intentions of Parliament were, I think they're fairly clear from that and from the EU directive. However, I am concerned that the use of the term gender in the 2014 Act may in future be open to greater ambiguity as a result of contemporary debates about the rights of transgender people. Gender and sex are distinct terms with different meanings, but in 2013 that was not so regarded. Now, latterly, I was inclined to support Johann Lamont's amendment, as I think it could or might put rest to any legitimate doubts that might exist. But I am concerned at the tone of some of this debate. I'm concerned that there has been no scrutiny of Amendment 28, and that for many people, this seems to be a debate about anything other than the victims of sexual assault. And so, in conclusion, Presiding Officer, I am concerned about the possibility of ambiguity. I would invite the Cabinet Secretary to set out how she might explore how this ambiguity may be resolved in future, and whether such legislation already on the statute books does indeed need to be clearer about the distinction in order to put any doubts to rest. And with that, Presiding Officer, I will be voting against the amendment.
Thank you very much, Mr Whiteman. Can I call Emma Harper, followed by the Cabinet Secretary? Emma Harper.
Thank you, Presiding Officer. This is a very serious issue, and access to a female examiner is extremely important, and work is ongoing. The evidence we heard at committee was focused on promoting the best care for survivors of rape and sexual assault. We were focused on supporting all survivors of rape and sexual assault and making the process of forensic medical examination a process where persons, mostly women, are supported in the best holistic way. And currently, in the NHS Scotland Patients' Rights Charter, which is underpinned by the Patient Rights Scotland Act 2011, it states that persons already have the ability to express their preference of gender in their medical practitioner. And for the purposes of this Forensic Medical Services Bill, there has been a concerted effort by the NHS and the Scottish Government to increase the number of female practitioners, both forensic medical doctors as well as forensic nurses. There are now 118 medical doctors, and 70% are female, and 98% of the forensic medical nurses are female. And that training is ongoing so that there is enough women forensic examiners. So I would like to seek maybe some clarity that when this amendment is passed, and I'm sure it will be, because words are very, very important now, and I know that there's been lots of discussion about how we differentiate between gender and sex. So when this amendment is passed, I just want to seek some clarity that the law already exists, that persons, women already have the right to express their preference over who attends, who examines or who interviews them. So I would like to conclude. I'd say I will support this amendment, but I would like to conclude by thanking everyone who participated in the bill process, including all the witnesses who contributed.
Thank you very much, Ms Harper. And can I call on the Cabinet Secretary, Jean Freeman?
Thank you very much. Presiding Officer, as I have clarified at earlier stages of this bill, neither the word gender nor indeed sex actually appear in this bill. The reality is that changing the wording from gender to sex in Section 9 of the Victim and Witnesses Bill Scotland Act 2014 changes nothing about how vital forensic medical services that this bill is actually about are delivered. My focus and my energies are directed to dramatically improving the provision of these services, and I will not be opposing this amendment. Should a woman be the victim of a sexual assault, she currently has the legal right to ask for a female examiner. That remains the case whether this amendment passes or not. All victims, irrespective of sex, gender identity or other characteristic, will be entitled under the bill to the same care and support. And importantly, further to a Stage 2 amendment, the principle of trauma-informed care now has much greater prominence in the bill. The bill now specifically provides that health boards must seek to avoid re-traumatisation. Victims are no longer examined in police stations, and the number of female sexual offence examiners on rotas has dramatically increased over the recent period. We need to do much more than that, and we need to go much further. In the second quarter of 2020, over 75% of examinations were carried out by a female examiner, and within the 3-hour timeframe specified in national quality indicators. And in nearly 90% of cases, forensically trained female nurse was present throughout the examination. I know all members will welcome this progress, but this bill and the point of this bill that should not be lost is about improving this even more. Presiding Officer, it should be noted that the meaning of the terms sex and gender are not defined by the 2014 Victims and Witnesses Act. The interpretation of these terms is already set out in law, including the Equality Act 2010, which contains single-sex exemptions whose use the Scottish Government has and continues to support where this is necessary and proportionately, such as in the case of forensic medical examinations. For that reason, changing the wording in the 2014 Victims Act makes no difference, as this amendment will not affect the operation of the underlying law here or the already established rights of women to request a female examiner. And for the same reason, whether the amendment passes or not, that does not, indeed could not, affect the rights of any other person involved in these vital services. Presiding Officer, in establishing the Government's position, I have of course consulted with my Cabinet Secretary colleagues, most importantly with Shirley-Anne Somerville as the Cabinet Secretary responsible for equalities. We are of one mind. We won't be opposing the amendment in this group because it does not and cannot change the existing and established law, rights and practice in this area, which we will uphold.
Thank you, Cabinet Secretary. And can I call on Johann Lamont to wind up and then to press or withdraw her amendment?
Thank you very much, and I intend obviously to press my amendment. Can I thank people who have contributed to this debate? And I would challenge all members who have reservations about it that they have a responsibility to raise their concerns, and so I appreciate those who have done so. I'm more concerned about people in this debate who are not saying anything, who are not engaged in the debate, but at the same time are calling into question my motives and the motives of those who have asked me to take this forward. If as a Parliament...
Alice Cole-Hamilton.
I'm very grateful to Johann Lamont for giving way. I believe that her remarks were directed at myself and my party, and that is in part down to the fact that we were wanting to listen to the debate as it unfolds. But I found the remarks of Andy Whiteman very compelling in terms of the range of propositions he laid out. So we will be opposing the amendment this evening.
Johann Lamont.
My apologies. I actually quoted Alec Cole-Hamilton's words in my own contribution at the beginning because I had found them so powerful. I was not actually talking about the Lib Dems because I recognise the pressure on time, but I am concerned that there are people who will not engage in the argument despite the seriousness of the issues. And I make that as a more general point, and are content away from here and away from when we debate these things to make assertions and allegations which are simply not true. There is no one in here or anywhere else pretending that this legislation or this motion will transform women's lives. I wish it were true. I wish by the stroke of a pen in support of this amendment that the pain the women who spoke to the committee could be erased. Nobody is pretending that any legislation on its own changes the world. Our responsibility is not just to signal what we would like to happen, but to will the means for it to happen. And it's my profound belief that this amendment will make a difference, because it will shift from saying, well, there aren't enough female examiners, to asking the question, how do we make sure there are enough women examiners? And I respond also to my colleague and friend, Monica Lennon. Forgive me if I focus on survivors in this debate. We should centre the experience of survivors and ask what is right for traumatised women. These women are not responsible for what people say on Twitter or on Facebook. These are women and men who are not responsible for those who choose to weaponise every single bit of politics that this country seeks to defend or argue. These are women who are traumatised and have asked through the years that things should change, and over time they have, and we should listen to them now. And if people want to debate the definition of what a man is and a definition of what a woman is, if they want to look at the Equality Act and change it, I am more than happy to be party to that debate. But that is not the argument we're having now. This legislation deals with what is the reality now of what a woman is, what a man is, and, oh my goodness, what abuse and violence are too. And we owe it to them to reflect on that. And on the question of conflation, I've got huge amounts of respect for Andy Whiteman as someone who considers things in great detail, but he makes the point that the words sex and gender no longer are argued in the same way as interchangeable terms that they were at one time, and I gave evidence of that already. And what women need and what survivor needs and what the law demands is clarity, not signals, clarity. And Monica talked about the role of rape crisis. From the very time when I was a young woman who began to understand what violence meant against women, I worked with and supported women who were far more courageous than me in establishing women's aid refuges and establishing rape crisis centres. And we had to win the argument that it was right that these services should be provided to women only. And it wasn't an easy argument, but we won it. And we're back there now in this argument. If we are not prepared to say, as the Equality Act says, that there is the right to women-only spaces and women-only services, and these will be protected. Rape Crisis Scotland and rape crisis centres at a local level have done immeasurable work to give voice to women, and those voices were heard in this debate. And my contention is that in supporting this small amendment, we are supporting the considered recommendation of a serious committee of this Parliament, and a committee that heard the voices of survivors and insisted that there would be change. It will not change everything, but it will give clarity to the rights of survivors, that they can ask in their most traumatised moments for support for female examination that might make that trauma a little less. And I hope that the colleagues in the chamber will support me in that regard.
Thank you very much, Ms Lamont. The question is that Amendment 28 be agreed to. Are we all agreed? Yes. We are not agreed. We are going to move to a vote, and members may cast their votes now. This will be a 1-minute division. second, Polly McNeill. That vote is now closed. If any members did have any difficulty, please let me know now. Point of order, Polly McNeill.
Yeah, at the last few seconds, it came up that I haven't voted, but I wasn't asked to vote, and I would have voted yes to the amendment.
Thank you, Ms McNeill. Your vote wasn't recorded, but I will make sure your vote is added and you voted yes. Point of order from Graham Simpson. Graham Simpson joined us remotely.
Yeah, presiding officer, I couldn't get connected. I would have voted yes.
Thank you, Mr Simpson. That is noted, and that will be added to the voting roll. Thank you very much, Mr Simpson. Thank you very much, colleagues. The result of the vote on amendment number 28 in the name of Johann Lamont is yes 113, no 9. There was one abstention. The amendment is therefore agreed. Can I call amendment 29 in the name of the Cabinet Secretary to move?
Moved.
Thank you. The question is that amendment 29 be agreed to. Are we all agreed? Yes. We are agreed, and that ends consideration of amendments. Now, at this stage, as members will be aware,